I have a bunch of missed tests. Then on August 30th, I have the alcohol shows up. On September 13th, alcohol shows up, and we have more missed tests. So between, I guess, the 16th, the date of this report, and the date you went on the tether back in August, how many times have you drank?
6 or 7.
Yeah, you just are continuing to consume alcohol, and you're playing with the testing so that it appears as though it's just a missed test, when in fact, what it is you're drinking.
Today we're in Judge Simpson's courtroom, where a defendant is asking the court for another chance despite repeated allegations that he violated one of the most basic conditions of his bond, remaining alcohol-free. Throughout the hearing, he insists the positive alcohol tests don't tell the full story. He offers explanations, challenges the results, and argues that the situation has been misunderstood. But Judge Simpson has heard countless bond violation cases before, and he knows that credibility matters just as much as the evidence itself. This hearing quickly becomes less about one test and more about whether the defendant can be trusted to follow the court's orders. Let's dive in and see how it unfolds.
Hey, Dustin, just state your name for the record, please.
Dustin Duncan.
All right. Your Honor, thank you for recalling this matter. So based on Mr. Duncan's appearance, I would ask the court to withdraw the bench warrant.
Well, you see the violation. The violation was the reason that I issued the warrant in this case.
Right, Your Honor. I've discussed the bond violation with Mr. Duncan, and Your Honor, to his credit, he did contact his community corrections agent and admitted.
When did he do that?
To consuming alcohol. The report indicates that he did, or it may have been the email actually that was sent out by Mr. Casey, where it indicated that Mr. Duncan did call him and admitted to drinking a twisted tea on September 13th, which is what ultimately led to the positive test on that date.
But
and then obviously we do have other issues. I'm aware of that, but at least he did admit to consuming alcohol to his community corrections agent. I can tell you that based on my discussion with Mr. Duncan, he has started attending some meetings with the Alano Club. He has reached out to Home of New Vision. He's an admitted alcoholic, Your Honor.
Pickett.
I understand all of that, but my other problem is that given the other sort of missed test, I mean, what about you say the twisted tea on the 13th, what about on August 30th? What were you drinking then?
Same twisted tea, Your Honor. I've contacted Home and New Vision Country.
Well, I just said that, but you're welcome to say it if you'd like to.
No, I didn't. I started talking. Contacted Mr. Leroy Pickett with Home and New Vision for a sponsor. I had 4 years clean and I relapsed. I know firsthand I need help with it.
Well, I understand all of that, sir, but so here's part of the problem that I'm having. Not only is there then these tests, he also has then missed tests, of which I would have to assume you're drinking.
Yes, I was.
So I'm going to ask you this, all right?
Okay.
I have a bunch of missed tests. But on August 30th, I have the alcohol shows up. On September 13th, alcohol shows up. And we have more missed tests. So between, I guess, the 16th, the date of this report, and the date you went on the tether back in August, how many times have you drank?
6 or 7.
Yeah.
8. I had 2 missed tests. I was in the hospital, but I did. Yes, I did.
You just are continuing to consume alcohol. And you're playing with the testing so that it appears as though it's just a missed test, when in fact, what it is you're drinking. And you really, quite frankly, need to go inpatient. I mean, you know you can't do this on your own.
Correct, sir.
Mr. Bowling.
Your Honor, Mr. Duncan is the sole care provider for his 95-year-old mother. I don't necessarily disagree with what this court just stated, and I don't think Mr. Duncan does either. Would the court consider allowing him to be put onto a scram tether?
As the hearing continues, the court reviews multiple positive alcohol tests, along with missed testing appointments. The defendant continues offering explanations, including medical issues and scheduling conflicts, hoping they'll persuade the judge that the violations weren't intentional. Judge Simpson carefully considers those explanations, but he also focuses on the overall pattern rather than any single incident. When someone is released on bond, complying with testing requirements is a condition of remaining free. Missed tests and repeated positive results naturally raise concerns about whether those conditions are being followed consistently. At this stage, the judge isn't simply deciding whether the defendant made one mistake. He's deciding whether the defendant has demonstrated that he can be trusted to comply with future court orders. What do you think? Should the court give greater weight to the explanations, or is the pattern of violations enough to justify a different outcome?
Pending getting into an inpatient treatment facility?
It's the reality is, in this type of circumstance, that doesn't help.
If nothing else, maybe it would be a reminder with a device on his leg that maybe he needs to call a sponsor if he feels like he needs to drink, or that he needs to attend an online AA meeting at any time of the day. Maybe the tether on his body would give a little bit more reminder than the SoberLink sitting on the nightstand table or the couch side table.
People have some concerns if you'd like to hear.
Yes, go on.
Well, the allegations include that Mr. Duncan was highly intoxicated at the time, walking into traffic, wielding a knife, trying to punch cars, making statements to incite a fight, continued that type of behavior when police arrived to take him into custody. My point in that is he was highly intoxicated during these felonies. So that's certainly a concern if he were to be released, even on a scram tether. At most, I would think the court could maybe consider a release to long-term inpatient treatment if you were to take him into custody. Thank you.
To adjourn the defendant's probable cause conference to September 30th, 2025, 9 a.m. And at this time, given the violations, defendant's bond is.
By the end of the hearing, Judge Simpson concludes that the defendant has not complied with the conditions of his bond. Rather than focusing on promises about future behavior, the court bases its decision on the defendant's history of compliance while already under supervision. Bond allows a defendant to remain out of custody before trial, but it comes with clear responsibilities. When those conditions are repeatedly violated, judges have the authority to modify or revoke bond to protect the integrity of the judicial process. Whether people agree with the ruling or not, this case highlights an important principle. Accountability depends not only on what someone says in court, but also on whether their actions consistently match those words. Now it's your turn. Do you think Judge Simpson made the right decision, or should the defendant have received one more opportunity to prove he could follow the rules? Let me know your thoughts in the comments below. If you enjoy real courtroom breakdowns, don't forget to like the video, subscribe to my channel, and turn on notifications for more courtroom content. Thanks for watching, and I'll see you in the next one.